Hello, I'm Natalia Angelini.
And I'm Domratchev.
Welcome to Hull Estates. You're listening and watching episode number 551. So today we're going to be discussing a very interesting Court of Appeal decision. It's Dujardin and Dujardin, and it's a very recent decision, June 29th it came out. And it relates to a will challenge and particularly deals with the question of the admissibility of expert evidence, which we thought would be an interesting topic to address today. So maybe we can jump in and start with the facts.
All right, so the facts of this case are Jacques Henry Dujardin, the deceased, had a brother, and they owned a farm jointly. That farm had been in the family since in around 1958. In 2009, they executed mirror wills, personal and corporate, leaving their equal interest in the farm to each other. Now, the deceased was actually married to Loretta June Dujardin, the appellant, and he did not provide for her in the 2009 wills, but he did leave her a RIF in the amount of $123,000, and that's pretty much it. Actually, she contended.
I think she had some. Yeah, she may have had some other minor interests, but
this was the most significant one.
Right, and it's also interesting to note that about 10 years earlier, the brothers had also done mirror wills that were essentially the same. They were very close, they worked together very closely, and they seemed to have this consistent intention to gift, their interest in the farm to the other. And that was, I think, so that was most definitely before the marriage. But the latter wills in 2009 were done not long after.
So they were married in 2000.
Oh, right,
and then the brothers came in to see their lawyer, who suggested that they draft new wills.
Right. In 2006, funnily enough, but they actually got around to it 3 years later.
Mm-hmm. Yeah. So in terms of, so we pretty much covered that. One comment that the trial judge actually made was that there was evidence that the deceased did not have a close relationship with Loretta. One of the biggest issues for the trial judge was whether or not Dr. Judson's expert testimony should be admissible. And Dr. Judson was an expert that was put forward by Loretta.
Right.
Now, she contended that the deceased did not have testamentary capacity because he was suffering from alcoholism.
Right, and a specific syndrome related to that. He was, I think it was undisputed that he was a daily drinker and he was a nighttime drinker. And the assertion was that this affected his cognition to the extent that he didn't have capacity. And it was interesting because he was, I guess, what we would call a functional alcoholic. Yeah. So during the daytime, I think to those around him, there was no evidence that he was impaired.
Yeah. So one of the comments that the court made was that he would work through the day and then he would come home and start drinking into the night. Mm-hmm. And so most of the witnesses who have interacted with him thought he was, and this came up in the decision lot with it,
right,
throughout.
Right. And that's really where the court landed it. So on this big question of do we admit this evidence, the court landed on the decision to reject or to not allow that expert testimony. And it wasn't just because all of the lay evidence was that he was fine cognitively. It was also because the expert evidence was very weak, and it got diluted over time when opposing experts had pushed back. I guess they had exchanged reports. Mm-hmm. There was pushback, and then there was a reply, and the evidence got so diluted that the court didn't feel it would be helpful to have that, incur the time and expense to have that evidence put forward.
Loretta also relied on the fact that the deceased had a heart attack in 2007. Mm-hmm. So to the extent that there was any confusion on the deceased's part, that was probably the strongest evidence where, he was on morphine, and I don't think it was disputed that he was confused and not very communicative at a certain point, but it seems that had not been a problem anymore by the time the wills were executed.
Right, it had resolved after a certain point of time, and that there was medical evidence to that effect. And so the court was really satisfied, and even cited our very own Ian Hull and Susanna Popovic-Montag in our McDonald, Sheard and Hull on probate practice, our 5th edition, where it states that the question of testamentary capacity is a practical one that, so far as evidence based on observation is concerned, may be answered by lay persons of good sense as well as doctors. So it's an interesting point because I think, in will challenge litigation, we all focus on the medical evidence and the physician's evidence, and you get the retroactive capacity assessments, but the evidence of lay people is not to be, underemphasized. It can be just as effective, if not more effective, because they've actually spent time and interacted with the deceased, whereas a doctor doing a retroactive assessment has never done.
Yeah. In this particular case, I thought a really good summary of the trial judge's decision that was commented on by the Court of Appeal here was that this case was fought and decided on the evidence of those who knew, interacted with, or treated Jack, not on the basis of experts who had never met or examined the man and who could only offer tentative views on the ultimate issue the trial judge had to decide.
Right.
I thought that was a very good point about just the interaction of lay witnesses versus expert witnesses.
Right, and it brings home the point of, do you always try and, once you get that expert opinion, do you always put it forward? Maybe you don't if it's not strong enough. And in this case, the objector was initially represented by counsel, but then self-represented at trial, and it was actually one of the other arguments made at the appellate level, where she was represented again, the expert evidence should have been admitted because she was self-represented, and there was another corollary point, but the court rejected that and stood by the rules of evidence, and they apply to all, whether you are self-represented or not.
Another point was that the drafting solicitor and his clerk gave, but based on this decision, seems strong evidence in terms of their interaction with the deceased.
Right.
And so the court put particular emphasis, I think, on their evidence in this particular case.
Right, and the fact that his decision in terms of how he was going to dispose of his assets made sense in all of the circumstances and was consistent with the past. So I think all of those factors combined led to this decision. And there were other issues that were addressed. We had the question of knowledge and approval that was addressed, and there was a new issue that was attempted to be put to the Court of Appeal that was rejected, but we didn't plan to get into that today, but we do invite you to read the decision if you're interested. We'll have it up on our webpage. And unless you have any other comments, Kira, I think that concludes our podcast.
No, I think that just about covers it.
Okay, so until next time, I want to thank you for watching and for listening. I'm Natalia Angelini.
And I'm Kira Domratchev.
Should you have any questions, please email us at webmaster@hollandhull.com or leave a comment on our blog.